Welcome, welcome. I think I've got noon Eastern, 9 Pacific here. So give everybody about a minute and a half to join. Looks like everybody's herding in now. For those of you who have attended these in the past, I always ask the always anxiety-inducing question of, can you hopefully hear me and see the screen? And so those of you who know, if you can just maybe raise your hands to let us know that you can hear me okay and see the screen okay. But let's see. Sure, I'm seeing. Oh, there we go. Thank you, thank you, thank you. Hands went up, so I got very nervous for a second. Perfect. Thank you, guys. Great, great. Again, give us another couple minutes. Well, I've got 12:01. I'm going to go ahead and get started. Last session on Tuesday, we had some great questions. So I want to give Reynolds a little bit more time to be able to cover those. So we'll go ahead and formally launch our informal webinar series. So again, I'm Brian Klontz with Charitable Solutions, and we've been doing these webinars now for really, I think since May 2020. I think this is our 35th or 40th one. And we're going to be talking today about charitable gifts of LLCs, the good, the bad, and the ugly. So Reynolds is the floating head that I hope all you can see now. Will be guiding us through today. So a couple quick housekeeping notes. So we will not, as in previous webinars, be sending out the slides directly. However, they will be sent out indirectly early next week. We will be compiling all of the questions that we received from Tuesday's webinar and the ones I hope will be good questions today. And we'll have those answered and then include that as part of the email. And Reynolds has also written an excellent journal article on this topic that will go much, much deeper than this webinar. And so we'll be including that in the materials as well. So we can expect that early next week. So again, with that, maybe Reynolds, if you would go to the next slide, I'll give you the 8-minute, I don't know whether it's shameless or somewhat shameless plug, but doing these for free, want to be able to make sure everybody knows all the weird stuff that we do. And so we've just celebrated our 20th anniversary. So you can see our new fancy logo we created about 90 days ago to sort of codify that a bit. And since day one, our mission has been to help make charitable gifts happen that otherwise wouldn't. And we do that through risk management and aggregation. And we do it in 3 primary areas, and we have some other sort of ancillary services in that ecosystem a bit. So I'll sort of start traditionally top left, our non-cash asset risk management. Many of you, I hope, know, some of you don't, which is the point of this, that we handle non-cash assets either as consultants, helping charities receive those directly, maybe 5% or so of our time, or just hourly and sort of consulting on specific asset cases. But by far the majority of our time is working with our Decami Foundation and Decami Asset Trust, which are national donor-advised funds that were formed specifically only to receive illiquid gifts. That's all we've ever done, all we plan to do. And then most importantly, for charities on the phone today, we never manage anything once it's liquid. So once it's liquid, there's a standing grant recommendation from the donor for that gift to be made back by grant 30 days after we receive liquidity, then that goes out. So very unsexy to say, but we're really just an intermediary or sort of middleman for these complex gifts, similar to what a separate supporting org or separate LLC might otherwise accomplish. We try to do that in an aggregated national way so charities can hub and spoke into us on a case-by-case basis as needed. We're also doing a lot more in the CRT space, not just for non-cash, but more broadly. So Paul Kasperson on our team, I think, has joined us today, is doing that where we can serve as trustee as well. Again, sort of in the risk space that where a charity might not otherwise wish to serve. On the non-cash side, you can see we've done a little bit over $3 billion. And these, very important to note, 100% of those gifts, 100% were initially declined by the charities that the donors were trying to offer it to in the first place. So we only get our referrals from charities that have some kind of complex situation, legal, tax issue, international issue, super quick turn time. So our average gift from initial phone call to completion last year was just over 4 days. that sort of mushes the real estate side and the private business side. But the point is don't say no to a good donor wanting to do good things with good assets. So that's non-cash. National Gift Annuity is kind of the same thing. We have a separate foundation licensed in all 50 states that can issue gift annuities. They can be illiquid, or by far the majority are liquid. Doing, I think, 3 now on the IRA QCD side. So not a flood of them, but a lot of conversation certainly this year. I need to update this. I think we're about 720 contracts, a bit over 60 million in assets. The key point then, again, as we are the aggregator, so we have the asset and the liability, but 100% of that residuum is then passed back to the charity or charities the donor was trying to give it to in the first place. So same sort of theme as you see. Charitable gift annuity risk management. We have a couple actuaries on staff, been doing this work since day one, basically stress testing larger gift annuity pools as consultants. To the extent that there's a very large gift annuity within that pool, or for various reasons, the charity and or donor wish to see the residuum sort of used more immediately or currently during life. In some cases, we then do design placement of reinsurance sort of as appropriate. Charitable appraisals. So we have now a team of 5 people that just do charitable appraisals. I personally do the cryptocurrency and the life insurance. We have 2 people doing business interests, 1 person doing art and tangible property, as I referred a case to him today, and then 1 person that does basically precious metals. So our little tagline there is, if you can give it to charity, we're supposed to be able to appraise it. So we're doing a lot more in that space, only doing charitable appraisals for the qualified appraisal 8283 sort of rules. Emergency Assistance Fund Administration, probably not what a lot of people sort of know that we do, but I created a charity 10 years ago that does relief grants for large employers for disaster relief and personal hardships. We have about 180 people on that team, touch over that. On the Charitable Solutions team, we've got 28 people, 7 attorneys in addition to myself. So they're very, again, separate and distinct, but same sort of thing. It's risk aggregation for employer-employee donation, so that we are a charity. So the donors, including payroll deduction, the foundations, the corporation or vendors can make contributions in a public charity to a public charity, but because we legally control the investments in the grants, that creates a separation between the employer and employee. And then we were able to make those grants then in a tax-free way, certainly domestically, and can have other issues internationally, which I will not get into. And then finally do things like this, which are professional advisors, CE, donors, board training, et cetera, staff. I have finished a gauntlet of May. I think it was out, I think it was maybe 12 days or something, 14 days, but don't have anything again until the fall. But we do have a number of people on staff that do on-site or webinar CE or training around particular topics. Obviously, sort of what we do, around the charitable planning space. So with that, hopefully that wasn't too painful. Again, I was sort of struggle with that. A lot of people will know us for one thing, going, oh yeah, you guys do virtual currency appraisals. Like, we do, but we have sort of multiple other heads to the Hydra and multiple other team members that are focusing on other sort of service lines. So it all gets back to the mission. We want to help people make charitable gifts. Otherwise, that wouldn't. So that's really the key. So I want to introduce Reynolds to sort of take us the rest of the way. I've known Reynolds a very long time. I joke as he knew me when I had hair, which I think is true. But Ryan Raffin is the managing partner on the non-cash gift side, who I think is on the call today too. Saw him do this similar presentation at CGP National Conference, and I sort of walked out of the room going, we need to get Reynolds to do this for one of our webinars, and Reynolds has very graciously agreed to do that. So Reynolds is an exempt org attorney, been doing it a very long time, partner in his firm, been chair of the CGP conference committee. So we're always in the sort of thought leadership space. So really, really glad that he was willing to do this for us. So Reynolds, I'll let you take it the rest of the way.
Great, Brian. Thank you for hosting this morning. So, or afternoon, I guess, for some of you. So we're going to be talking about charitable gifts or charitable planning involving limited liability companies. And basically, we'll go over a little bit of the history of how the LLC came to be. We'll talk about some basics, the state law rules surrounding the LLC, as well as all of the different ways that an LLC can be taxed. And then we'll look at sort of 2 angles for you, the receiving of a gift of an LLC interest, and then ways that maybe the charity would form an LLC to facilitate gifts or other activities of the organization. And then finally, we'll wrap up with some conclusions. So the limited liability company, at least when it comes to popular legal structures for businesses, kind of came out of an unlikely place, and that was Wyoming. Normally, people think of Delaware as the leader in the formation of new innovations and business entities. But it was Wyoming that came up with the idea of the LLC. And what they were looking for was a simpler structure than a corporation that would allow for oil and gas interests to be held in something that would have limited liability, but be simple to operate, and also have pass-through taxation, meaning it wouldn't have two layers of taxation with a corporation. And prior to the existence of the LLC, you had the choice of the corporation, which had limited liability, but it had more complex operation. And unless it qualified as a subchapter S corporation, it had two layers of tax. Well, they came up with this thing in 1977, and not much really happened with it for over a decade, because the IRS didn't give any clear guidance on how the entity would be taxed. And it's very difficult to use an entity if you don't know what the rules are for taxation. But finally, in 1988, they issue guidance saying that the LLC, if it has multiple members, can be taxed as a partnership. And they also create this very simplified form of taxation that if the LLC has only one owner, it can be a disregarded entity, meaning that it's basically ignored for income tax purposes. The income is taxed to the owner, and you don't have to file a separate tax return. So once the IRS explained how these things were taxed and adopted rather favorable rules of taxation for LLCs, interest in them exploded, and states start quickly adopting LLC statutes. We get a uniform LLC statute. And by 1996, all 50 states have LLC acts allowing creation of LLCs under their state laws and mechanisms to recognize LLCs created under other states' laws. So very rapid expansion. The basic legal structure, so the name tells us a lot about it that makes it attractive, and that's the limited liability. So the owners of the LLC are not responsible for the contracts that the LLC enters into. So if the LLC goes out and borrows money and then ultimately can't pay it back, it's only the LLC assets that are at risk, at least assuming the owner didn't sign a guarantee. Similarly with tort liability, if the LLC owns a building and somebody slips and falls on those premises, then it's the LLC assets that are at risk, not the assets of the owners generally. The next thing about them that's helpful is very flexible management arrangements are allowed. By default, generally, the LLC is managed by its members, but the LLC can appoint a manager or a group of managers who are responsible for the operations of the LLC. And within the agreement, you can allocate powers and decisions between managers and members pretty much any way that those parties want those decisions set up. Another thing that's nice about the LLC is minimal formalities are required. With a corporation, in order to ensure that the corporate limited liability, the corporate veil, as they say, is respected. You need to have a board of directors generally. That board needs to meet periodically. You need to keep minutes of those meetings. So more formalities with the LLC. The managers can basically make decisions and just keep whatever notes of their decisions or deliberations that they think is appropriate, but there's no requirement of formal minutes or formal meetings in order to manage the LLC. The governance of the LLC, extremely flexible. Almost all of the terms of the operating agreement are subject to the agreement of the parties. So you'll have an LLC statute in each state that will have some default rules as to different aspects of the LLC, like allocation of profits or withdrawing of members. But in almost every case, the statute will have something to the effect of, except as otherwise provided in the agreement, these are the default rules. And so as to almost everything, you can change it in your operating agreement. So it gives you a lot of flexibility. And as I mentioned, now all 50 states have acts. Delaware is, even though they didn't invent the thing, they have become one of the choice places to form LLCs and have one of the most flexible statutes. In terms of governance, one of the most recent innovations is something called the Series LLC. And that's where normally when you form an LLC, the old LLC, you had your members. And if you were a 10% member, then you were basically a 10% member of an owner of everything that happened in the LLC. And so, for example, if an investment fund formed an LLC and you became a 10% member of that investment fund, then each company or deal that the investment LLC did, you would own 10% of it. Well, some venture funds wanted to be able to give their investors more flexibility and an ability to basically participate on a deal by deal basis rather than having to sign up for every deal that the fund was going to do. Well, prior to the Series LLC, that would basically require forming a new fund for every deal. And well, the basics of a formation of an LLC are fairly straightforward. When you start going and selling it to investors and so forth, new funds require a lot of disclosures and extra work around them. So what the Series LLC does is it allows a single LLC to be formed, but then essentially sort of sub LLCs within it. So the company can, the investment firm can say, all right, this is deal one, and somebody can own 10% of deal one, and then they can go to deal two, and maybe they own only 5% of that, or they don't own any of that. And then deal three is another series, and they can own some different percentage of that. And all of the liabilities and sort of the economics of each series is separate from the other series, even though it's all within one sort of large LLC. So if you get offered a gift of an LLC, you might find that what you're getting offered is a gift of one or two, series within the LLC. So taxation of the LLC, very flexible here. The LLC can be taxed either as a corporation, it can be taxed as a partnership, or it can be taxed as a disregarded entity. With corporate taxation, at least if it's treated as a C corporation, then you have taxation at both the corporation level, and then the dividend when it's paid out to the shareholder is taxed. LLCs can elect to be taxed as S corporations, and then you have a single layer of tax just at the level of the shareholder. If the LLC has 2 or more members, then it can be taxed as a partnership. And under partnership taxation, the partnership puts together a tax return, identifies all of its income, but the partnership doesn't pay tax. Instead, it allocates all of the income to the different partners, and then the partners pay the tax on the partnership income. And then finally, there's disregarded entity taxation. And there the LLC is ignored for income tax purposes. It doesn't get its own employer identification number. Instead, all of the income is reported on the Social Security number or employment ID number of the sole member who owns the LLC. Now, that status is only available if there's a single owner. In community property states, a husband and wife or spouses that own an LLC as community property can consider themselves as a single owner for this rule and have it be a disregarded entity. One of the things about flow-through taxation, so this basically you get the effective flow-through taxation if the LLC is taxed as a partnership, if the LLC is taxed as a disregarded entity, or if the LLC is taxed as a corporation and has made an S election, then the LLC, when it receives income, it'll get the cash, and there'll also be taxable income that initially is at the LLC level. Well, the cash can stay at the LLC level, but if it's flow through taxation, the taxable income and the obligation to pay the tax on that income will always flow through to the member. So if your organization is being offered a gift of an LLC interest, you want to look at, is this flow through taxation? And if it is, what kind of income is flowing through to us? And what kind of cash is flowing through to us? Now, as a tax exempt organization, some forms of income, even though the taxable income flows through, you're not going to need to worry about it. If it's, dividend or interest income, you don't pay taxes on that. But if the LLC is an operating business and generates unrelated business income, or if the LLC has debt and that creates debt financed income, then either of those situations will mean that taxable income that's flowing through to the charity will generate an actual tax liability on the part of the charity. And so there you're going to want to see, well, are we at least getting enough cash each year to pay our tax liability? A lot of investment partnerships, but by no means all, will have a what's known as a tax distribution clause. And that's a provision in the agreement that says that the LLC will distribute at least enough cash each year to its members so that the members can pay the tax that's due on the taxable income that's flowing through to them. That is going to be subject to the LLC actually having enough cash to do that. And, if the LLC had some kind of, non-cash taxable income, like possibly cancellation of debt income or something, it may not be able to make that distribution. So something to look at. One of the things that we sometimes do when we get gifts of LLCs that might generate UBIT, you obviously first look to see if there's enough cash flow, but you might, as a backstop, also ask the donor to indemnify the organization if there's ever a situation where it's receiving taxable income and not enough cash flow to pay the tax. If the LLC is generating unrelated business income because of debt, then there is what we call the 5 and 5 rule that says that if the donor has owned the property for 5 years and the debt has been on the property for 5 years, than if it's either received by inheritance or it's a gift to the charity. There's a 10-year holiday where the charity does not have to pay unrelated business income tax. When you're doing the look through on this rule, one kind of interesting wrinkle, the debt needs to be secured on property of the LLC. And I had an unusual gift a while back. It was a very large real estate partnership. They had some debt. We thought we were going to be able to take advantage of the 5 and 5 rule, but we found out that the ratio of the debt was so low relative to the total assets, and the cash flow of the LLC was so strong that the lenders were providing the loans on an unsecured basis, and they were not taking deeds of trust against any of the property of the LLC. And so that created the unusual circumstance that when that LLC was being inherited or bequeathed to a charity, the charity was not going to be able to take advantage of the 5 and 5 rule. So the first thing we're looking at here is just sort of a gift of some kind of an LLC interest and some of the things that the organization needs to look at. And it's a more challenging asset to accept because in terms of business interests, because some entities, once you kind of know what the entity is, for example, if somebody is giving you publicly traded stock, you generally know what your rights and responsibilities are with publicly traded stock. You have limited liability. Publicly traded shares are not subject to call provisions where the company can tell you you have to contribute to, so if you buy a share of Google, Google can't call you up and say, oh, we're demanding a capital call on your share of Google. You get dividends, that those are not subject to UBIT. You might not get any dividend at all, but if you do, you know what that is. So just knowing that you're getting a publicly traded security, that tells you an awful lot about what you have and what your risks and obligations are. Not true with an LLC. With an LLC, because everything is kind of subject to changes in the operating agreement, you have to really read through carefully the operating agreement to see what your obligations are, what your benefits are, and so forth. And some things that you'd want to be looking at are capital call provisions. Can they require you to pay in capital to the LLC? We talked about tax distribution, what roles you might have in management. Also, what are the terms for changing the LLC agreement? Right now you look at the agreement terms, they're fine. You're probably going to be a minority member. Could they change the LLC agreement adversely later without your consent? We've talked about unrelated business income. You want to look and see, whether that's a possibility. Does your organization already file a 990T, or is this going to be something new for you? And then finally, the liquidity. What's the exit strategy? An LLC is not going to be publicly traded, so some venture funds, investment funds will have provisions where investors are allowed to ask to be redeemed. There's usually some period of time over which they're paid out. Others may have no redemption options. So is it possible the donor or somebody related to the donor or the other members of the LLC might be interested in buying your interest, or is there a plan to sell the underlying assets or sell the LLC itself at some point in the future? If you just try to sort of sell these things to buyers of them, the discounts are quite steep. We had a situation not long ago with a client that was looking into that option, and the silver lining for me on the estate planning side, people say, oh, those discounts you take, that's just, made up, they're not real. And well, go try and sell, a minority interest in a non-public traded LLC, and you'll find out the discounts are very real. So the diligence list that you need to look at if you're considering a gift of an LLC. It covers an awful lot of stuff. You'll need to get the operating agreement we've mentioned. You probably want to look at least 3 years of financial statements, 3 years of tax returns. If it is an investment fund or something like that, then there may be an offering memo. If there are big assets, it's got an apartment building or something like that as its main assets, then you want to get some background on the value of that and how it's operating. And then finally, who's running the show? Who are the managers? What information can you get about those? So one kind of an interesting structure of an LLC that you might see an offer of a gift of is something called the Up-C LLC. This is a setup to help investors in companies that eventually go public. So when you form a new company, particularly in the technology space, very early on, you're just contributing a lot of capital to the company. The company is spending that capital, trying to develop its platform, acquire users, and so forth. And there's not much in the way of revenue, because the idea is to grow the platform fast, get lots of users, and then start figuring out sort of the revenue side of things. So the early investors want to have a flow-through entity where those losses are coming through to them and they can use them on their own tax return. So early on in forming these companies, they often are formed as LLCs with flow-through taxation as partnerships, and then the investors are getting those losses. Well, at some point they decide to go public. Even after the company goes public, it may be that they're still expecting to be generating losses for some extended period of time. And if that's the case, the original investors, who tend to be high net worth individuals, might still want to have those losses passing through to them. The public company will need to be a C Corp in order to be publicly traded. So the losses would not pass through. They would get trapped at the C Corp level. So the Up-C structure, what happens is you form this public company, you sell those shares to the public, the revenue from those sales comes into the public company, but the original investors have continue in their LLC, and that LLC forms a partnership with the public company. And then that operates the actual business. And so losses can still flow through to the original founders, but you have access to that public cash. Well, at some point, the original investor wants to get out. And so this structure allows them basically at any time, based on a formula, to convert their LLC units into shares of the public company that they can then go and sell. Well, when they do that conversion, when they exchange the non-publicly traded LLC units for the publicly traded stock, that's a taxable exchange. So if they exchanged $100,000 worth of LLC units for $100,000 worth of public stock, and let's just say they had only $1 of basis, then they would have $999,999 of taxable income when they did that exchange. So what they might do is come to your organization and say, hey, I want to make a gift to you, and I'm going to give you the LLC units. And then once you have the LLC units, you exercise the exchange right. And then if you want, you sell the public stock. And so the charity would get the LLC units. The donor would take a fair market value deduction. It's not publicly traded, those LLC units, so you'd need an appraisal. And then the charity does the exchange for the public stock, and then if it wants it, it sells it. And so it's a great gift if you can get it. You need to look at the details to make sure that there's not any surprise limits on your conversion right. Another area that you may see these are using LLCs in estate planning. I already mentioned, we take these discounts in estate planning. But one of the issues that people doing planning with LLCs have is that the value of these interests, they hire appraisers, but it's a little bit of art in addition to science. And there's always a risk of the IRS coming back and disagreeing with the value. And there's a long line of tax court cases that said, you can't just sort of make a formula gift of, okay, I only want to give away 100,000 of this. So if the IRS comes in and my appraisal's wrong, well, then the amount I gave away gets changed so it's only 100,000. For many years, the tax court had said, no, that you can't take away, the IRS's incentive to audit by using some kind of a formula. But then we had the McCord case where the taxpayer said, well, what I'm going to do is I'm going to give an interest to my family, or sell an interest to my family worth a set dollar amount. And then I'm going to give to charity an interest in the LLC that's everything over that set dollar amount. And the IRS said, no, this, this doesn't work. This is the same thing as these other formula clauses, not allowed. And the tax court said, no, now we've got an unrelated third party here. And if the value changes, then the family has less, and it's not coming back to the other members of the family. It's going off to this charity. So there's something more going on here. And so we'll respect this formula. So we saw a number of families making gifts to charities. Now, the trick was that they would get an initial appraisal, and usually based on that appraisal, the amount coming to charity was a pretty small amount, and it would only be if the IRS came and made a substantial adjustment that the interest of the organization would change. And then the other thing is, oftentimes the family would come and try to buy the interest from the charity. And so even if the change occurred, the charity might not own what they had anymore. And usually there wasn't like a clawback or an adjustment in that sales clause. So you may see these transactions. A couple thoughts about them is they are complicated. You have to do your own diligence on the value. Generally, when I've been involved with them, we've required the donor to make an additional cash gift to the charity to cover the costs of the charity's appraisers, the cost of the lawyer time in looking at this, and so forth. But done right, there may be a valuable gift for the charity in these formula clause, yes. A potentially abusive situation are gifts where the donor forms an LLC, places a highly appreciated asset in it, donates 99% or maybe even 100% of the LLC to charity, but the donor or related party to the donor is the manager of the LLC, and generally it's structured so that the charity has no ability to remove that manager. The LLC then sells the highly appreciated asset. It now has cash. No tax gets paid because all of that gain got allocated to the charity. But the donor manager then decides, well, a good investment of this LLC cash is a loan back to the donor at a relatively favorable interest rate or something. The IRS has looked at this transaction. They're not amused. It's resulted in some criminal charges. So definitely one to avoid. Now, not every gift involving an LLC where a lot of the LLC gets given to the charity and the donor still has a role in it is abusive like this one. Sometimes the donor may have some expertise in managing the asset that's in the LLC, and it makes sense for them to have that continued role. It's also a vehicle that's sometimes used where, you know, the donor has a lot of investment experience and they want to continue to manage the investments of the LLC. So a big hallmark that is a dividing line between the potentially abusive ones and not is what ability does the charity, who is generally the sole or close to the sole owner, what ability do they have to remove the donor as manager of the LLC? And you know, the greater they have an ability to check any abuses by the donor as a manager, the more likely it's not abusive. And also, you know, the structure in terms of having the donor in there as the manager, is there a benefit to the charity in doing that? Is that the reason we're doing it? Or, you know, is it really just so that the donor can keep control of the assets after they've allegedly given it away? Another structure that we have seen in the news and some interest is something that's called the, and it's a confusing name because sometimes it's the same name, another variation of charitable LLC, but very different from the structure we just discussed. This is where somebody forms an LLC, and Mark Zuckerberg and Michelle Chan were sort of the first ones with some publicity about doing this. They formed a single member LLC. They said it was for charitable giving, you know, put some language in the LLC document for charitable purposes and put a bunch of Facebook stock into it. But they still owned the LLC. The LLC itself didn't get tax exempt status. They didn't get any income tax deduction for forming that LLC, and that LLC gets no special tax benefits. The only tax benefit occurs when they actually make a gift of the stock in the LLC to another charity. Then a deduction flows through to them. But I mean, they could have just held on to the stock, not formed the LLC, made a gift of the stock, and gotten the deduction otherwise. So these structures are, you know, for people who want to, you know, publicly identify some stock that they're going to give away and create a structure around that. Another variation I've seen is sometimes individuals who have several different philanthropic entities will form an LLC to kind of coordinate the management among those different organizations. But it's a pretty fact-specific type of structure that probably only a few of your donors ever would consider or need. So now we're going to shift to uses of the LLC structure by the charity. So this is generally where the charity is probably going out and forming the LLC in order to do something. And some of the different situations where the charity might use an LLC is to accept a gift of a risky asset. So somebody has some real estate and you have some concern that there might be environmental liability. So you might form an LLC and have them donate that real estate into that LLC. Another reason is maybe the charity is starting up a new activity, new exempt activity, but it's got some risk to it. You know, maybe it's a private foundation that decides it's going to run a summer camp or something. So you put the activity inside the limited liability company so that if there are liability issues, you can contain them. Another reason for doing it is if you want to separate out the governance. So the charity has its board of directors. They're responsible for governing the organization. Now you're going to run this new activity, and maybe because it requires special expertise or something like that, the normal board of the charity isn't really the right group to run it. So you want to have another group of experts overseeing that activity. Well, you could have them be an advisory committee, but then the fiduciary liability stays up with the board. So you could form an LLC with a group of managers who are the experts for that activity, and then they would be the fiduciaries. And your regular board would not have general fiduciary responsibility for the activity. The IRS issued a ruling several years ago that says if you've got a single member LLC that's a disregarded entity, then when somebody makes a donation to that LLC or a gift to that LLC for Section 170 purposes, it's as if they gave it directly to the charity, and they can claim their income tax deduction. One thing to watch out for, though, is the LLC is disregarded for income tax purposes, but at least on the federal level, but it's a valid state law entity, and that is distinct from the charity itself. And so other exemptions that the charity enjoys, the LLC will not automatically enjoy. For example, sales tax exemptions. If the charity has a sales tax exemption, it may not automatically apply to the LLC. The LLC may have to separately apply for that. Or it might be that the state law doesn't, allow for the LLC to have that. Property tax exemptions is another one where we see oftentimes LLCs require some additional work. More recently, the IRS has issued guidance on circumstances where the LLC can get its own 501c3 status. So that sometimes is an opportunity to deal with these issues. We just had a client who found out their LLC structure that had a lot of cash flow was going to be paying a large city business tax, gross receipts tax. And we got it 501c3 status, and that eliminated the need to pay that tax. But that process basically converts the LLC into something taxed as a corporation. It's now a tax exempt corporation, but now it has to file its own 990 and so forth. So the simplicity of the disregarded entity taxation disappears. In charitable remainder trusts, we sometimes use LLCs. With the net income unitrust, we can use the LLC as a vehicle to determine when that net income trust will have income that would be distributed to the donor or beneficiary. As we mentioned earlier on the taxation, the cash goes to the LLC. The taxation flows through to the owner, which would be the CRT. So the cash can stay up in the LLC. Well, in a net income unitrust, the income, when it pays out the lesser of its income or the unitrust amount, the income there isn't taxable income. It's what we call fiduciary accounting income. And basically, you, in most circumstances, don't have fiduciary accounting income until you have a receipt of cash or maybe a receipt of property. So if the LLC is holding on to all of the cash and doesn't distribute it, then there's no trust accounting income. And then the lesser of the trust accounting income or the unit trust amount, well, if the trust accounting income is zero, that's the lesser. And so it doesn't make a distribution. At some point in time when the donor wants distributions, then the LLC can distribute cash. Now the CRT would have trust accounting income, and a distribution can then flow out to the donor. So potentially a helpful tool when, the flip trust is great if you have a single time that you want to sort of switch on getting distributions. But if you don't know that single event or time, then this net income spigot unitrust is potentially a great way to go. you need to look carefully at your state principal and income act, though, to understand how that cash coming out will be treated as trust accounting income. The Uniform Principal and Income Act has a pretty simple rule that unless otherwise described, up to 20% of the value of an entity can be distributed out and just be called trust accounting income. California has adopted a look-through rule where you have to see what was the source of that distribution. Was it the sale of an asset or was it something else? The Uniform Law Commissioners are looking at revising that. So look and see what your own rules are, because you do want to be certain that when the donor decides that they want to have some cash, that what you distribute will be characterized as trust accounting income. So we've just hit our conclusions, and then we'll look at some of the questions that have popped up in the chat. You know, one thing to remember: if you've seen one LLC, you've seen one LLC. Because of the flexibility of the governance in the operating agreement, and because of the flexibility in how it can be taxed, you have to look at each LLC and understand all of its details and features. LLCs represent a number of planning opportunities for both charities and donors, so it's definitely worth the risk and the effort here, but they do, particularly because of the flow through taxation and the possibility of you know, changes or provisions that you're not used to in the operating agreement. There's risk there, and if you've been sitting here listening to this whole presentation and looking at your organization and the staffing and the resources that you have available and saying there's no way we can do this, then Brian is your friend, because that's exactly what Decamai is set up to help do. So instead of turning the LLC donor away, if you know it's just not within the capacity of your organization to do all of this diligence, then talk to Brian and see if he can help you out. So let's take a look at the Q&A. All right, I'm not seeing any there, Brian. So did you take them out?
No, I actually answered them as I went along. Thank you for the plug, by the way.
Oh.
So now we're going to have a fun part, which we've never done before. I will ask you the questions that I answered, and the key is that you need to hopefully answer them in the same way that I did. So kind of a joke, but we'll sort of ask it the same way. So a couple of them, Reynolds, have been around the valuation piece. So two that I'll sort of mush together is sort of, since the valuation discounts are so real and steep, sort of do these still make good charitable gifts if there are these sort of larger discounts? And so I had sort of provided some general quick answers there, but would love to get your sort of comment there. And then sort of a sort of little mini side question to that is sort of how much of a discount is typical on the charitable side relative to a minority interest. And he had sort of mentioned, is it like 5 to 10% or so with the charitable piece? So.
So it you know, it still potentially is a good gift. I mean, even though the donor isn't able to you know, realize that for the deduction, the you know, the underlying assets, what people don't realize is you know, when you make a gift of General Motors stock, you know, it's trading at X, and you're like, oh, okay, the stock is $100 today, I get $100 deduction. That $100 value of the GM share, that represents a minority discount. It doesn't represent a lack of marketability discount, but it does represent a minority discount. And the way we know this is, you know, every time somebody says, oh, so-and-so has made a tender offer for publicly traded company X, and the tender offer is, you know, X dollars over the currently trading value, that's because whenever you buy the whole company, then you pay the control premium. So in a way, when you give away the LLC interest, yes, you go out and you get that appraisal and you can sort of see that discount. But basically the same unseen discount, at least for lack of control, is happening to you when you make your gift of your publicly traded stock. What is the discount? That is very, fact intensive, and will depend a lot on the terms of the agreement. Probably the most important influencer of the range of the discount is within the agreement, what provisions are there for liquidity? If this is an investment fund where the managers are, willing and able to provide liquidity on, 15 days notice or something like that, and you can, cash out your capital account on that basis, then the discount is going to be quite small, maybe even non-existent. On the other hand, if this is, an LLC that owns an apartment building, there's no withdrawal right, there's no liquidity rights. You're going to have to go out and find either a member of the LLC or somebody else who wants to buy into that particular apartment building and go through the diligence of a private sale like that. You could be looking at a discount in the range of 30 to 40%. The other thing to look at is, is the family, are they making gifts of this interest to family members at the same time that they're making the charitable gift? And if they are, and they were all excited about that 30 or 40% discount for the gift that they're making to the child, they have to be consistent with the gift to the charity. And I think there was a case not that long ago where, somebody got slammed pretty hard on that, saying, oh, when I gave it to my family, it was worth $2. And when I gave it to charity, it was worth 10. The IRS and the tax court weren't amused. All right, did we match up? This is like a
I think
weird
so.
version
Yeah, I
of the
think
dating
so.
game.
Exactly right. Well, the funny thing, like 8 more questions, well, probably more 6 real ones sort of shot into, but so what I had sort of mentioned too, Reynolds, what we see is one, you're exactly right. If there's sort of the intra-family gifting that's occurring at the same time, that's sort of a whole other set of circumstances that those discounts need to be consistent. But what we have seen is where it's sort of just a standalone charitable gift. Either sometimes we use put options, maybe in about a third of the cases, where we can actually create a market back to the donor to allow us to put that back, which could squeeze potentially out or at least mitigate that. And then the other one we see often is, let's say it's a apartment complex or something that is in an LLC, that rather than using the market approach, the appraiser might use the income approach, which typically there aren't as many discounts, so they're basing that on a derivation of cap rate. So there can be some ways. Usually it's a way to be able to communicate to the appraiser, look, we're looking for the smallest discounts possible that's justifiable. And then obviously you're signing off in the 8283 and they become the lightning rod. In some cases that works. Another question, another one that came up is, do you ever see UBIT blockers so on the LLC interest gifts? We don't see very many of those at all, unless it's sort of an international thing or sort of part of, hedge fund type LLC. But what do you see on the blocker side?
Yeah, I mean, so the UBIT blocker, that's where you basically form a C corp and you interpose that between the charitable organization and the LLC or the whatever it is that's generating the UBIT. And so then if anything is coming out of the C corp, it's dividends to the charity, and so they don't generally pay tax on dividends from C corps. But it's not saving you any taxes generally, because the C corp, you're paying the corporate tax there. Now, I guess if you were a trust form charity, sometimes the C corp rates might actually be lower for your UBIT. You might do it for that. The other thing is we have now the UBIT silo rules that say that if you have unrelated business activity A and unrelated business activity B, if those two activities aren't basically the same thing, then the losses from A can't be used to offset the gains from B. Well, if you just put those both into the same C corp, C corporations can have all kinds of different lines of businesses. They don't have to be related at all, and they all can come together and you can use the losses against the winners. So you sometimes see it there, but it is a fair amount of machinery. It's you're setting up yet another entity and so forth. So you really have to weigh the benefits versus the costs of maintaining the structure.
Yeah, exactly. When they're there, we're happy, but we've never seen one created sort of de novo for a charitable gift, at least from our perspective. So what I'm going to do is probably just go ahead and close us out. I want to thank Reynolds so much. There are a number of other questions coming in. Those questions will be answered. And so again, we're going to take all these questions, take the ones from Tuesday, mush them, and then have the answers as we've done in prior ones too. But just want to thank Reynolds so much for, again, this. I think if you go one more slide, Reynolds, just so they can see the list of past webinars. I included that to one of the questions, but again, all these are free. It's about 35 or so that are there. If the slide doesn't go forward, totally fine. They can just go to the Charitable Solutions LLC.com website under resources and webinars. So they'll be able to see all those there. And sort of a final point, sort of Reynolds just mentioned the trust form. So our Deca My Asset Trust is a trust form Nevada donor advised fund sponsor for UBIT mitigation. So we've done at least $500 million, at least in S Corp and LLC, active LLC, or debt finance property UBIT, and so we're able to get the UBIT cut down usually to 8% is the effective federal rate for capital gains and 14.8% for ordinary income based on our 60% of AGI deduction, at least so far. So there are structures that exist out there to sort of, we're talking about the UBIT, whether it's a blocker. We don't see the blockers again as much, but we're able to use sort of that structure to be able to mitigate UBIT pretty hard. So in any event, thank you so much again, Reynolds. Thank everybody for their time today. Hope it's been helpful. And again, we'll be able to post the questions and the webinar link early next week. So thanks, everybody. Good luck.